All right. Good evening, everyone. Thank you so much for taking the time out of your busy schedules to join us. Greatly appreciate your support and hope to provide tremendous value during the time that you've invested this evening. My name is Jon Harris. I'm a managing partner with Fortune Management, and part of the inspiration behind doing more of these virtual events and the podcasts that we also do and those kinds of things is more or less just being a student of learning and constant never-ending improvement. So I try very hard to associate with very knowledgeable, trained, and experienced professionals who have a lot more knowledge in areas that I think are of value to not just myself, but to the vast majority of us. And so I've tried to assemble a team of those people across the country who are very knowledgeable in their fields. And I think it's incredibly important for us to build our own quote unquote board of directors that can help guide us as CEOs and business owners in the right direction and making sure that we're making sound, effective executive decisions on both the personal side and the business side. So tonight is a little bit about more on the personal side than anything else. And so I have Mr. Ben Bush with me. If you guys have attended any of these that I've done in the past, you'll recognize Ben. He is a financial planner, a managing partner with Northeast Private Client Group, Northeast Sequoia Private Client Group. And they work with a lot of our clients who are predominantly dentists across the country, although they're not necessarily limited to dentistry. I know that you work with people, and as a matter of fact, you're my financial advisor, so you definitely work with people outside of dentistry. So, but I've worked with Ben for many years now. He's an incredible resource for me. I don't make any kind of substantial financial decision without sending him a text. And so I recently purchased a new home and needed to decide what to do with my previous home, and I didn't know whether to keep it and rent it or sell it, and all those kinds of details. So I sent him a text. I said, "Hey, give me 5 minutes, give me a call, help point me in the right direction." And so I think it's incredibly important to have a team of people around you that have experience and knowledge that you don't have. So Ben, thanks so much for joining us this evening.
My pleasure. Good to see you, John. Always. Thanks for inviting me on again. I really do like coming on to these webinars and sharing some information for everybody that I think is widely not distributed during our educational years, and as we start to get into our planning in life and jobs and family. And this one is fairly important for everybody. It drives up and down the ladder, regardless of sort of income levels. Estate planning is something that everybody should be involved in. And so I'm glad we're doing this.
Yeah, this is the research and stuff. This is an area where my knowledge is very limited. I can certainly appreciate the impact on the operational side, like how do we drive the revenue to fund the machine, right? But really, from what I know, is it's incredibly complex. I mean, incredibly complex. You've got trusts and wills and tax exemptions, just a variety of different obstacles that need to be navigated. And because those waters are so difficult to navigate, it makes a lot of sense to have a team of people help do that. And so unfortunately, Richard Miller has not yet been able to join us. He's a certified elder law attorney with Mandelbaum Salzburg. When you get rolling in here just a minute, I'm going to text Richard and see if we might not be able to get him on, because there's 3 sides to this equation, really. 4 sides to this equation, really. One side is the operational side, and it's the earning side, like, increasing your earnings to produce the revenue that's available in the cash flow that's necessary, to build something, worth protecting. And just accelerating your financial plan. One side, obviously, is the area where Ben's expertise is particularly important, and that is in the financial planning side. We've also got the accounting side and the tax strategies and where all that stuff fits in, and then ultimately the legal side, because it is, again, it's a very complex legal environment. There's a lot of, having insurance plans inside of trusts and outside of trusts. And at the end of the day, I think your high net worth individuals and your high earners, I think the model for success there is going to be earn as much as you can and get taxed on as little of it as you can. I mean, if that's the 30,000 foot view. And so we hope to cover at least a couple of those this evening. We may even need to do this again and bring in a CPA along with Richard if he's not able to join us this evening, because there is a lot that goes into this.
So it's really it's the integration of all of those areas that you just mentioned. But it really, I mean, for everybody, this is almost like financial planning or financial strategy, where the world of estate planning begins the day you start working, the day you start making money, paying taxes. Certainly when you expand into a marriage and a family. And as many of our clients, John, are business owners and building businesses, sometimes multiple businesses, that world gets more and more complex. And it is the integration of all of those areas that you just mentioned. And that's what makes it, I think, sometimes a little daunting for people. But to simplify it, it's really just keeping control over your assets, even when you're not around to necessarily make those decisions. And that could be because you're overseas, out of the country. That could be because you're indisposed, your health is declined, you're not physically able to make those decisions. Or of course, if you pass on and you're deceased, having a solid estate plan that speaks to all those issues you mentioned, the legal side, the tax side, liquidity, taking care of your family and those that are important to you, and it extends out charities, special needs, family members. So, it's very important, and it's something that I think is often neglected, not intentionally, but just one of those things that's not really fun to address. For many of us, is like, okay, what happens when I die, right? What happens if I am indisposed, if I'm sick, if I can't make decisions? And so very often this finds itself on the back burner year after year after year after year. It's one of those things when we talk to clients, quite frankly, it's, oh, I know I need to do it. And we'll have that conversation again and again and again. And it's, I know I need to. And ultimately, it sort of needs to be pushed. One of the jokes that I make is, the client that is a properly formed estate plan and the right amount of life insurance never dies, right? The only thing you hear on the news when people die is they have no estate plan. They didn't have coverage for the family. They didn't protect the family, and they didn't plan for the disposition of their assets. And there's famous stories all the time, from James Gandolfini to Prince, many
Jackson
celebrity cases that had just millions and millions and millions of dollars of assets and no estate plan, and it's left up to the courts of their state to dispose of those assets how they see fit. So, very, very important and complex topic.
Yeah, it's incredibly interesting because we spend our careers accumulating assets and building wealth and all that kind of stuff. And the last thing that we would want to do when we pass this life is to leave a burden on the people that, our family or our kids. And so earning a lot of money is not necessarily very beneficial to everyone without the proper protections in place, because, if you leave this life with a lot of liability, obviously that's going to be a burden on your family. You can also be incredibly burdensome on your family by leaving a lot of assets without the proper protections in place. Because you've got, like, for example, if my sister, for example, let's say I passed tomorrow and my sister took over everything, that's essentially a full-time job to figure out how my assets are going to be distributed. Now, I'm fairly young in my career. I still have a long way to go. So I certainly haven't accumulated the wealth that a lot of people have. A lot of people on this call have, probably not, and certainly not the amount that I intend to. But one of the questions that I have, and this is why this topic, I guess, is a little scary for myself and others, perhaps, is at what point does it make sense? Like, at what point do I have enough that makes sense for me to protect it?
So, from a planning perspective, I will tell you that the minute you start accumulating some type of asset, it's already in place, right? So I guess the point is there's an estate plan in place for you, whether or not you chose it or not, right? So I live in New Jersey. We have clients all over the country. Every state has what they call intestate laws. And so I think let's take a step back and talk about what happens to an estate when somebody does ultimately, when they die and their assets are then going to be distributed. So there are three different ways that assets are distributed. Okay. One is by title. So if I own something jointly with you, right? So you and I have a piece of real estate and it's owned jointly. Now, there are different ways you can own jointly. You can own jointly with rights of survivorship, jointly with tenants in common, depending on the state that you live in. But if it's by title, so if my wife and I own a house together and we own that jointly with rights of survivorship, if I die, she automatically takes ownership of that house, right? So with rights of survivorship, states specifically in that ownership clause that if I die, she has the rights of ownership and not at 50%, at 100%. Where joint tenants is a little different than that, right? Joint tenants is actually, you and I can own a property. I own my 50%, you own your 50%. If I die, my joint tenants in common, my beneficiaries, the people I choose, get my 50% of that property. It doesn't go straight to you. So by title is important. Many things that are owned jointly, that can be bank accounts, it can be homes, it can be real estate, it can be businesses. Title is one way that property can transfer. The second way is by beneficiary. So there are many things that are listed that have a beneficiary designation, some by law, and some you can create, like trusts, by which you can distribute those assets by naming somebody specifically. Most commonly, we think about retirement plans. If you have a 401k or an IRA or a Roth IRA or a simple IRA, you are asked to name a beneficiary on those accounts, similar to life insurance. The importance of that is if you have a named beneficiary, those assets will transfer to your beneficiary as soon as you supply a original death certificate and the beneficiary designation. Those assets can transfer over to that beneficiary. So this can happen in a matter of weeks when somebody passes away. And that's often, not to jump too far ahead, where trusts are created, right? There are often times that we create trusts specifically just so things pass by designation or by beneficiary, as opposed to the third way, which is probate. Okay, probate for many of us is how a lot of our assets get transferred. Physical assets, bank accounts, homes, cars, whatever is not titled either by beneficiary or title is going to go through probate. And probate is through the courts. So probate is, we're going to read your will. You're going to have what's called an executor or executrix who's going to manage that estate. They're going to take the will if there is one, and they're going to gather up the assets and distribute them according to the will through the court system. If there is no will, the court will distribute via their intestate laws.
Is that because, is it done by the courts because people don't have a beneficiary designated or don't have a...
So probate is always done legally. So probate, even with a will, means it's going through the system. But if you have a will, that you bring it to the courts. Now, people can challenge a will. You hear about this sometimes. People can make that. And I think that's where having an attorney is important, because it probably can speak to more of the legal ramifications and outcomes here. But when it goes through court, if you have a will, you have stated what your choices for disposition of assets are. And typically for a more simple estate, many times I would like my spouse to get everything except for maybe a few simple bequests. Often in a will, you might have what's called a testamentary trust, which means if I die, I would actually, if my spouse and I die at the same time or she predeceases me, I would like a trust created upon my death that the assets would flow into for the benefit of my children, right? So that my children would sort of be protected from themselves. So those assets wouldn't be just given to my children or their named guardians. So having a will is very, very important for really what we're driving down to. And when you said, when do I start? Like early, because if you have children and you don't have a will, the number of choices that have to be made on your behalf are immense. Like, who is going to be the guardian of those children, right? The court is going to decide that if you haven't made that election, right? Who is going to manage the assets or the money that is positioned to take care of those children? Now, that could be the same person. It might be somebody different, right? But if nobody's listed, the court is going to decide that. And then the court actually decides the disposition of the assets. And it may not all go to your spouse or your children. They may decide, depending on the state, what their intestate laws are, that it could perhaps go some to your parents, some to a sibling. People can make claims on assets at the court. They can say, I was promised that I was going to get an asset or this bank account or this amount of money. So probate is when it goes through the courts. Now, if you have written a will, it's your most recent will that lays that out. It tends to go more smoothly unless if somebody does challenge it, that you have laid out. This is exactly what I want. Here's my executor or executrix. That's who I want to handle it. Here's going to be the guardian of my children, if that's necessary, of my minor children. Here's going to be the trustee of my testamentary trust. You will always lay out a primary and contingent in these cases. So there's some security in place in case if something has happened to somebody else. And the disposition of assets. Here's how I'd like them distributed in the event of minor children, at what ages I would like what percentage distributed. So it gives a lot more control over the disposition of assets. The reality is most of us will live a long time, but when you're looking at the law of large numbers, we know this. Some people don't, and we don't get to choose. So it's important to really start establishing this stuff early. Mm-hmm. You need a will, a healthcare proxy, or advance directive. Power of attorney, we also recommend talking about, whether it's full or durable power of attorney to a spouse, meaning they can actually act on your behalf and for any situation or for some specific instances, whether it be healthcare, finance, or a springing power of attorney. Springing power of attorney is if I become physically or mentally disabled, that would spring into action, that somebody could actually have that authority. So those are the basic documents.
HIPAA release also becomes important there, does it not? Because if you're over the age of 18 years old, your health information is now private. And I was actually reading about a story where a kid who was 18 years old got in an automobile accident or something. They got life flighted to the hospital and he was basically comatose. His parents couldn't even find out what hospital he was at. And that took several days before they could even find out which hospital. Then they couldn't make any, help guide any decisions as far as, do they resuscitate? What happens there? They didn't have access to his information at that point.
That's a great point. We actually tell the story a different way, but we often will recommend to parents of children when their children are 18, 19, if they're going off to college, to have a power of attorney for healthcare, a healthcare power of attorney or advance directive. What you're talking about is an extreme case, but when we talk about, we hear the story of a college kid who maybe did go a little too far one night, maybe had an excessive night, maybe got dehydrated, ended up in a hospital. The emergency contact is listed as the parent. The parent gets the phone call. College could be hours away from a drive. It could be a plane flight away. All they know is their child is in the hospital. Mm-hmm. They are not allowed to disclose what the condition is, what the condition of the patient is. They just say, hey, you're the emergency contact. We know that your child's in the hospital. And now the parents are on a mad dash to get to the hospital, which could be just for a minor dehydration issue or too much drinking or whatever the case may be. So we will often make that recommendation is to have that on record. Also, there are some very clever tools from estate planning where a lot of times you'll get these documents and you can have them all on a thumb drive. You need to make sure they're accessible because of these circumstances. You also have to be able to prove that you have it, right? What we say sometimes is when you need to show these documents, they're often not right at your fingertips. So make sure that you have the facility to grab those documents and be able to prove that you have a healthcare power of attorney for children or a financial power of attorney. So very, very good point. Good question. And again, that's why all of this stuff is important. You don't have to have a $50 million estate to have proper planning in place.
Mm-hmm. Now, this doesn't just wills and trusts and estate planning doesn't necessarily just pertain to the death of an individual. It also pertains to the incapacitation of an individual, correct?
Yeah. When we were growing up, when I was younger, there was a big famous case that came about, a woman named, I think it was Terry Schiavo in Florida. And that, what you mentioned came up, which was she was incapacitated and they went to the courts. I don't remember what party is on which side of the conversation, but was do we keep her on life support or not? And so that was the sort of famous example when I was a child. It does happen is who has the authority to make those decisions if I'm incapacitated? But take it a step further. I mentioned it before. if you travel overseas, if you have something happen, we often as parents will do this when we travel. We'll leave a written note with our health insurance card saying that my mother or mother-in-law has the authority to make healthcare decisions for my child. Right? If I'm away, I happen to be overseas and unreachable, but my child has a visit to the hospital, who has the authority to make those decisions, right? So those kind of pieces in writing. So that would be almost a temporary power of attorney. But from an authority standpoint, there are many situations that may come up that don't require death, or don't have death as an issue, but you're not around to make decisions. There could be financial decisions that have to be made, and you can't be reached on the phone at a particular time, right? And that's where when you sit down and talk to an attorney and you go through the conversation of power of attorney, they will walk you through the different options that are available, the number of the sequence of items that are available to provide or to offer power of attorney to somebody else, where you can show up and show your power of attorney and signature and say, I have the authority to act on my wife, husband, child's behalf in this space. So yeah, it could be very important. And that's the point. These are all unknowns. And like none of them are going to happen to everybody, but one of them is going to happen to everybody. You know what I mean? Like of the millions of things that could happen to us that are a 1 in a million chance, one of them is going to happen to us. That's an old Neil deGrasse Tyson tweet.
Yeah, I hate that my mind goes here, but I think about that a lot because the amount that I travel, I'm on the road constantly. I see the way people drive, and it stands out in my mind. I saw a vehicle kind of, passing everybody in the right lane and then squeezing behind a tractor trailer to get in front of the car. And it's like people gambling with people's lives on the interstate, 24/7. And I look at the amount of time that I spend on the interstate. And then also look at the fact that I have a very, very bad habit of occasionally trying to do work while I'm driving on the interstate. And so I was actually today, as a matter of fact, it's interesting that we're having this conversation tonight. The concrete, when they shut a lane down, they put those concrete that are like 3 feet high. It's like a wall. I thought I hit that today. I was trying to send a voice text to someone, and I thought I hit it. I didn't. My tire kind of went up on it a little bit, but it didn't damage my vehicle. But it was like, man, it's that fast, man. I mean, that quickly, I might have been in a hospital and not capable of making any kinds of decisions as far as my business is concerned, as far as anything. So, I mean, it makes a lot of sense in my opinion. As I get older, I'm beginning to appreciate protection a lot more and security a lot more, as opposed to just historically, my thought process has just been go, 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 grow, 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 and now it's interesting that I'm kind of starting to appreciate the balance.
I think that's, not to get into psychology. It's true for all of us, right? When we're young, we're indestructible. There's no reason to do a lot of this stuff because nothing bad is going to happen to me. And as our prefrontal cortex actually forms and we get more responsibility and thought process into our mid-20s, you start to get a little bit more realistic about what life is, and you start to see a little bit more. It does happen. And so historically, you will see that people not only start to plan from an estate planning perspective and a protection perspective, but it's also true with financial planning and business planning is getting more serious. Those things tend to settle in a little later on. It's a good friend of my partner, Mark Murphy, says that, I've never met a young 20-year-old who I didn't think was at least a little bit brain dead. Right. Yeah. So it's all of us. And it was me too. But it's still, it's almost just saying, and many of our clients, right? So we have clients that become business owners in their 20s. We have clients that are starting to do big things. We have clients, as you said, that have accumulated debt that can be transferred. We'll talk about that in a second. That's an important piece too. And so the impetus, the purpose, the reason for the planning is there. But having this conversation, right? Like this isn't a great, happy conversation. This is sort of we need to try to find every angle that life can come at us and have a drastic impact and try to close the door on that as much as possible. Yeah. Right. And that's sort of what risk management is. Risk management is one of three things. You can either accept the risk. Go, it's fine. I'll take it on. head first, and that's okay. It fits into my plan. I'm okay accepting that risk if it happens. It's not going to devastate me or my family. It's good. That's acceptable risk. 2 is I'm going to transfer risk. I will risk pool with other people, right? And this is sort of the fundamentals of insurance. I will take my risk. I'm going to put it into a pool with a lot of other people's risk. And although it may happen to a small number of us, if it happens to one of us, we've protected that person. That's the basis of insurance. Or 3, I'm just going to avoid the risk completely, right? What you're talking about, I appreciate. I put in a lot of miles in my car too, but there was a period of time when I lived in Manhattan, I didn't have a car. That was fantastic, right? Not having a car, not having any concern around accidents, automobile insurance, and driving. So when you're going through these kind of planning conversations, when we do it with clients, most of our clients, I would say, have recognized that the opportunity to create wealth in their life exists in investing in themselves, right? Putting that money back into themselves, building and growing a business, building and growing a real estate portfolio, financing deals, doing those things that we always talk about that can create real sustainable and multi-generational wealth. And once they grasp that concept, pretty quickly after that comes the mentality of, I just need to protect the house, right? What I need to make sure is that my opportunity to go execute on these plans and strategies to really create that wealth and accessibility for my family and future generations just doesn't stop because of something that's out of my control, right? And that's where this kind of planning comes in, to say, recognize that it can happen, no matter what the probability is, and then do one of those 3 strategies: accept it, transfer it, or avoid it, right? And that's in large part where estate planning comes in. It's saying, okay, I accept that risk can happen. If it does occur, we're just making sure that I have control over the outcomes, even if I'm not there to speak for myself, if I can't take action around it.
I like that. I like the 3 ways to mitigate risk. That's good. Okay, so if I'm not mistaken, the 2 most commonly, and I'm a little confused as the difference between a will and a trust, and I know that the 2 most commonly used tools in estate planning are the various forms of life insurance, and then also trusts. So before we get into those 2, can you help clarify for me what is the difference between a will and a trust? Are they the same thing? Is it interchangeable language, or are they completely 2 different vehicles?
Yeah, completely different. A will, and I probably should have it up because we have a nice little quick 13-page white paper that really talks about this, and we'll make that disclaimer that all of this information should be discussed with a estate planning attorney and somebody who really lives and breathes in this space. But a will is a document.
I've decided what I'm going to do with this. This is obviously going to go on my YouTube channel. We're going to do this again, and I'm going to coordinate better with Richard. We're also going to get a CPA to join us who has a lot of experience in this department. And this is going to basically be basic estate planning, and then we're going to do an advanced. And the advanced will get into a lot more of the technicalities of this whole conversation.
Yeah, absolutely. A good idea, because we definitely want to have a good attorney's view on this. They spend years not only studying it but living in it, so they can speak to it. But a will is a document that's created to do several things. Avoid distribution under laws of intestacy, right? So that's one of the things that I mentioned. Gives you control over how your assets are being distributed. It permits the nomination of guardians for minor children, right? If something is to happen, who do I nominate to be the guardian of my children? It also allows you to make specific bequests to individuals of your assets, and the ability to sell assets during the administration of probate. Another thing a will can do, it can authorize the continuation of business as opposed to shutting it down, and it can defer distribution of money to minors specifically, right? To either 18 or 21 or beyond that. So those are some features of a will, but a will is a document that is really, it's there to achieve those things and make that transfer process more concise, clear on the wishes, and make that probate process go a little better. And what is also not necessarily known, but is true, is if a married couple goes out and gets documents, each one of them gets a will, right? I have a will, my wife has a will, right? 2 separate documents that are done during the same process. A trust when you talk about trust, and there are a lot of different types of trusts out there, right? So when you talk about a trust is creating it's a new entity that has its own tax identification number. It can own property. Now, there are two designations of trust that we will typically hear: a revocable trust and an irrevocable trust. A revocable trust means changes can be made. When you have a revocable trust, that most often means that money still, or the assets in that trust still belong to you. They live in your estate. They're part of your estate. And you can put things in and out of that trust. A revocable trust is very often used to avoid probated debt. So I can have bank accounts, I can have my house, I can have assets in my revocable trust. I can sell those things and touch them. But the minute I die, it becomes irrevocable and avoids the probate process. Then it goes to the distribution of assets is according to the trust document. An irrevocable trust, in many cases, means I'm actually giving away control of the asset. In fact, like a trust is almost like another person. I'm giving my asset to somebody else. Now, not to get too far into the weeds here, because again, there's a lot of different types of trusts, but very often those kind of trusts are utilized to get assets out of the estate, out of ownership, that wouldn't then be subject to a possible transfer of estate tax. Okay. So a trust is a new entity. It's a separate entity that will file its own tax return, that has its own management, that has a trustee that oversees the decisions of that trust. If it's an irrevocable trust, often trustee won't be the person who put the assets in. That's the grantor. The grantor is the person who provides assets. The trust will have beneficiaries. So those are two different things. Sometimes they will designate the creation of a trust upon passing. But a trust is its own separate entity that can own all kinds of property.
Okay. What would you say are the primary, at what point would you advise someone, hey, we need a trust, not just a will?
So again, I think this is when you'd probably want to talk to an attorney, and an attorney that understands the state that you live in. Okay. So a lot of attorneys we work, we're national. So an attorney in California might have very different advice than an attorney in Tennessee or Florida or Texas or Hawaii or New York. Right. When to create a trust, there's a lot of factors that might go into that. When I mentioned that revocable trust, a family trust is sometimes what it's referred to. A lot of attorneys in various states will say, hey, our probate system here in this state is not very favorable. It takes a long time. As soon as you have a decent amount of assets and income, and I don't know really how to quantify that because that's also different state to state, so it's not a number, right? So that once you have assets that are starting to build, you might have some attorneys that say, hey, this is a good idea. Let's set up a family trust. Let's have your family trust own a lot of these assets. So if and when, it's a when conversation, something happens to you, we're circumventing the probate of the state, right? That trust is going to dictate the disposition of the assets. It can happen in a timely fashion and a lot more control. In terms of trusts that we are going to create for broader exclusion of the estate tax, right? To try and get assets out of our estate necessarily, or leverage assets out, whether that be a GRAT or a charitable remainder trust or those kind of things. Typically, we will do that in your higher net worth individuals. You'll start to see those pop up when you start to see assets in the higher range. The difficulty there is they change the law on us all the time, right? So in Washington, there is no set amount that this stays forever. If you followed this going back probably 20 years, there was at one point, I remember when I was in business, so this is within the last 20 years, the exclusion, which means the amount that you can exclude, that you can own without having tax going to the next generation, was as low as $1 million. And then at one point it was $3.5 million per person for a married couple, so $7 million total. And then the estate tax went away for this like minute period of time. There was no estate or transfer tax. And the only reason I remember that is because George Steinbrenner happened to magically die during that period of time, right? So billions of dollars, no estate tax. and then it jumped up. And what happened was during the last two administrations, there was an estate tax set up it was $5 million per person, so $10 million for a married couple. That was unified with gifting, meaning if you gave away money while you were alive or dead, the $10 million is exclusion. So you had $10 million to give, and none of that would be taxed federally going to the next generation. Mm-hmm. Over and above that, you would have to pay the federal transfer tax or estate tax. In the last administration under President Trump, he effectively doubled that. And so with inflation, with the adjustment, it went up to almost 22 million, which is where it sits today. So a little over 22 million for a married couple, 11.4, I think individual, 22.8 for a married couple. That's scheduled to sunset back. And so this is a lot of grief. But what I'm really saying is, yeah. But what I'm saying is it's really difficult so if you live in the Northeast, if you live in New York or Northern California, you have a business, a home, and some assets, you may not be rich, but a couple of years ago, you might have been subject to an estate tax transfer, right? Very, very possibly could have had over $3.5 million living as a middle class, just there. And then as they raise it up, which I believe is sort of the intent for many people, is the estate tax should not touch a lot of people. But as they change the laws, the planning has to change. Mm-hmm. So, people will create trusts under current law, and then the law changes and you go, oops. So another one of our big pieces of advice, when we're talking about setting up trusts and creating irrevocable trusts and putting assets into that, try to avoid making permanent decisions under temporary laws whenever possible, right? If you're going to be giving away the ownership and access to assets, be very careful about doing that. Right now it seems reasonable. If you've got a $50 or $100 million estate, you need to do some planning, right? But if that comes back down to 11 million and you've got $8 million, I don't think you need to act right away. But the federal government keeps acting like a yo-yo, and we haven't even talked about what the individual states do. Individual states have their own estate.
Is it generally Republicans generally try to push that number up? Democrats would try to pull that number back down. Is that right?
Sure. From a philosophical standpoint, yes. The Republican side of the aisle typically either wants that number to be very large from an exclusionary standpoint, or just say it shouldn't exist, right? To say, hey, the transfer of my assets to my next generation should exist. Democrats, again, I don't think I can speak for all Democrats. I don't think that's how it works, but usually you will hear that they want that number to touch a certain percentage of higher net worth individuals to generate tax revenue to pay for programs, right? They identify that as a way to cover some costs. So depending on who's in office and how they set the law, you will see that change. That was something that was sort of on the table. There was a lot of estate planning issues on the table during this the new administration. A lot of them ended up, as of now, not getting put into the bill. But that was one of them. So right now it's still at the $22 million, 22.8 index for inflation. But it is going to sunset, right? So we're already doing some planning based on what could happen or what will happen in 2 years, not knowing who's going to win the next election and what that law is going to look like.
Just seems to me like that's an important variable to kind of keep your thumb on when there's a changing of the guard politically from one party to the next party. This is something that affects everyone. And depending on, how long, whatever the bill was passed and how long that particular rate's going to last, where I'm at in life, what my planning is suggesting, that affects your taxes significantly. Because you look at the difference, from 11.4 million to 5 million. Like I'm going to pay estate tax on anything over 5 million. Well, if I have 12 million, that's a significant amount of tax.
Big.
Yeah.
And it's a big tax.
That's a huge number.
But bringing something else, actually. So that piece of it doesn't necessarily touch a wide range of Americans, but there was another thing that was brought in the most recent bill that could touch a lot of Americans, and this is another transfer tax target, right? Because when they're looking to generate revenue, right, to pay for programs, they're going to look at anywhere that's not currently tapped or could be tapped a little more without generally hurting the majority, right? I think that's the intent of how do we generate revenue without hurting the vast majority of constituents or Americans. And one of the things that they had actually talked about was eliminating what's called the step up in basis. Okay. So that's a fancy way of saying, I own a home. John, you own a home. You just bought a new home. Congratulations. A lot of homeowners, they own their home and they may live there, not for 7 years or 10 years. Some homeowners will own their home for 20, 30, 40 years, right? Longer. So when you talk to somebody who bought their home 30 or 40 years ago and they're living in a retirement, and this is all over the country.
Right? I already know what you're about to say.
They go, I bought my home back in 1965 and it was $40,000. How much is it worth today? It's worth $850,000. You go, that's amazing. So great. Now, when that person dies and their children or child or children inherits the home, under current law, their children inherit it as if they bought it at the current price. Mm-hmm. So if it was worth $850,000, they inherit it, and if they sell it, there's no tax to pay. So one of the things that was on the bill to discuss that was being tossed around was getting rid of what's called that step up, where the children inherit it at the actual cost. To say if the children inherit it and they sell it, they're going to have to pay the capital gains tax on the difference from when it was bought back in 1960.
That's insane.
That applies to homes. That applies to investment accounts that are not in retirement, right? And so that was a big thing that was tossed around. And again, this goes right back to, you need to have your finger on the thumb. You need to have this up, because if that would have passed, that affects a lot of people, right? And then it was, okay, well, that's only going to apply to people with estates at a certain level or income. And so there's always, and that's our job, right? I don't think the people that are listening to this, I'm not saying to you that you need to be constantly listening to what's going on in Washington and paying attention to the estate tax issues and what could come up. But we are saying, which is going right back to the beginning of the call of our meeting here, is you need a team of people that are paying attention to that, right? It probably doesn't warrant your time if you have the right team around you that's paying attention, that can come to you and say, hey, this might be an issue for you. This might require some planning. This might require an adjustment in some of our current strategy. Maybe we start gifting stuff with a warm hand instead of waiting with a cold hand, right? That's something we talk about a lot with our more elderly clients. Is it appropriate to give while you're alive? It feels a lot better. You get to experience the giving of that. But sometimes they don't, because of those step-up basis rules. It actually makes more sense to wait till you're dead. So people go, no, I'm going to wait because I don't want my kids to worry about paying the tax on that. Yeah. So as those laws evolve, as the parties in Washington create those laws and bring them up to vote, we are paying attention to it. We go down to Washington. We talk to legislators. We talk to lawmakers, and we figure out where they are and what they think is going to happen. So we can come back to our clients and say, hey, let's do some planning if we need to. Or it doesn't look like that's going to pass. Not going to be an issue. We don't have to worry about it.
Yeah. Another one that I heard recently also, and I'm not sure what happened. I'm assuming that if it had gotten passed, there would have been an upheaval regarding this legislation, but it was unrealized capital gains. So if I've got a brokerage account and I've got $100,000 in there, and I made 15% on it last year, then when I file my taxes in 2021, I'm going to pay tax on the 15% appreciation, even though I didn't take anything out of it. So that would not just affect like a brokerage account, that would affect your IRA, that would affect your real estate, any asset that you own that appreciates in value. You're paying unrealized capital gains on that appreciation. That seems just like crazy to me.
Well, yeah, and that's not there because it's not realized, right? That's not part of the bill. You're right. It wouldn't actually occur in retirement accounts. And so retirement accounts specifically are protected from that to entice you to save for retirement, right? So even if you have a lot of unrealized gains, they get continued tax benefits with also penalties for accessing that money to promote savings for that period of your life. But I'll tell you what, when it comes up, basically what happens, there's a list, right? There's the list of everybody knows is what's available, right? What can we talk about from a tax perspective? And this is where estate planning is a tricky business, and why having qualified help with a great estate planning attorney, having an accountant who's paying attention to this, having that board of directors feel is important, because the law is ever changing, right? Mm-hmm. What we're talking about today is going to be outdated maybe next year, maybe in 4 years, but for sure the laws will be different. And so that's why you can't give specific advice on calls like this. Here's what you should do, because there's no permanency to how estate planning is done. You need to be cautious with it. You need to really think about what are your desired outcomes from a legacy perspective. Make sure that you have satisfactory streams of income for your life, making sure you're not giving away anything that's going to harm your ability to live for a long, healthy life and worry about outliving or having access to money. And then work with advisors to create an estate plan that fits that mold, that also ideally has some flexibility in it for when laws change.
Very good. Very good. Can you tell me anything about life insurance trusts? You've got revocable trust, irrevocable trust, and then life insurance trust. That's another form of trust?
Yeah. Well, so there's several. There's something called an ILIT that is commonly referred to as a life insurance trust. It's an irrevocable life insurance trust, ILIT. You can use life insurance in a number of trusts, and it is an estate transfer strategy that's often used for your higher net worth individuals. Because if you think about life insurance by design, it's a leveraged product, right? So life insurance by design is you pay smaller amounts of money over a period of time to transfer larger sums of assets much later in life. And so a lot of times life insurance inside trust can be utilized, one, to move money out of your estate, right? So if you have a life insurance contract, so let's say you have a $3 million life insurance contract, that is in fact a part of your estate. That's $3 million that is value in your estate. If you die, that's part of your estate. So when we talk about that exclusion, right? If that exclusion was $5 million and you have a business worth $2 million, a home worth $1 million, IRA or retirement account worth $2 million, and life insurance worth $4 million, that $4 million is counted up. And so you could easily jump over that $5 million in that situation. And so what you may consider doing is creating a trust to own that life insurance. Remember what I said about irrevocable trust is it's no longer in your estate. You have given that asset away. And so you transfer that away. And what you're actually doing then is you're gifting the premiums. Now, as an important estate planning tool, you are allowed to gift. At this point, it's $15,000 per person per recipient without getting it counted against your exclusion or anything else, right? Doesn't hit the radar in terms of the IRS. $15,000. So you can gift $15,000 of premiums. If you're husband and wife, it could be 30 into that trust to help pay the premium, and therefore that large death benefit is now out of your estate and can transfer outside of your estate and not subject to the estate tax. Well, often what that might be utilized is actually to pay some of the estate tax, right? So if you have a large estate, you might do that strategy so your children can receive the life insurance and pay the estate. The million ways to skin that cat. And again, I don't want to get too into the weeds, but for a lot of our clients who are subject to the estate tax, a lot of that money is not liquid, right? People own assets. So if you have real assets like real estate or businesses that aren't readily liquidated, remember when you die, for the most part, you have 9 months in probate. So for children, it's a liquidity event to say, hey, great, my parents left me all this real estate. We've got a business that we own. There's 6 of us kids. We don't want to dilute or sell the business to pay. So the life insurance can inject some liquidity into the estate to help cover some of those taxes. So a lot of different ways that life insurance can be utilized in estate planning. Again, you want to find out if there's a real need, and 2, if there's a solution that works, that's going to get the outcome that you want. What I will tell you this too, John, is we do sometimes find that people are too quick to put their life insurance in a trust. Remember, life insurance has other benefits, sometimes living benefits, sometimes access to capital, right? You can have cash value in some life insurance. A lot of times life insurance will have the ability to leverage or use that cash as a line of credit. And so once you put it into that trust and give up ownership to it, you may be giving away access to all that capital. And that's where we talk about making permanent decisions in temporary situations. So definitely something you want to consult professionals based on your situation and what the desired outcome is. Because once that's out, it's there, it's in that box, right? And you're not the trustee and you don't own it anymore. And so it's got to be done with precision. And it's important to have those conversations and understand the consequences of all these different pieces and make sure you're pulling the right levers to get your desired outcomes.
So let's back up really quick because I'm a little lost, or not lost, but this is where I'm um, just need some clarity. So in the example that you provided with the business and the house and the IRA account and all that is up to $5 million, and then you got $4 million, and I guess life insurance. You would take the $4 million, put that over into a trust, and then is at that point, because there's a point at which the life insurance can begin to pay the premiums on itself. And so it's just kind of sitting there and it's building cash value and appreciating in value, and it's not costing you a dime out of pocket. Right.
Sure.
So creating a scenario like that, and then where, let's say, for example, it's paying you $15,000 per year, because if I'm not mistaken, that gift tax is annual. So it's I can gift $15,000 per year tax free. So is that what you're referring to? Like the whole life policy is paying me $15,000 a year, and the $15,000 that okay.
No, it's the other way. So create a trust. If the idea is you need to distribute assets out of your estate to cover some estate tax liquidity issues, or to cover some possible estate tax, and you realize that you're over the exemption limit, in this case, $22.8 million as we sit here today, you may elect to take a insurance policy and put it into an irrevocable life insurance trust or a GRAT. There's a number of different trusts that can be utilized.
Mm-hmm.
Now, the exclusion, the gift tax exclusion, specifically states I can gift up to $15,000 per recipient. So I can give $15,000 to you, John, and I don't have to tell the IRS I did that. I don't have to report that. It doesn't go against my $22.8 million exclusion. Okay. And I can do that for as many people as I want. I can give $15,000 to my kids, my grandkids, my nieces and nephews, my friends, and a trust. A trust, again, remember, is almost like another person.
Okay.
So let's say that
I gifted it to the trust,
because let's say it's early, right? Let's say I'm 45 years old, 50 years old. Let's say my premium is $30,000. My wife and I could take $15,000 each, gift that premium, gift the $15,000 each into the irrevocable life insurance trust, and that gift will then cover the premium for the insurance, and it doesn't show up on the exclusion, right? And so now that multi-million-dollar policy is being gifted, is being paid for using that $15,000 exclusion, doesn't touch the $22 million, but it's providing liquidity ultimately to my named beneficiaries, the beneficiaries of that trust, to some way solve some estate planning concerns that we've identified and that we've recognized as that's one solution that might be beneficial. So that's the gift tax, and that could be used a lot of ways. I mean, we have families, by the way, that are literally just gifting their children and grandchildren $15,000 per person per year as a way to give while they're alive and get that money out of their estate without any gift tax consequence.
That's actually pretty smart too, because now you're just if you've accumulated, I don't know, whatever, 15,000 times. Well, let's say what would that be? 15,000 times 150,000. Right? You can pull 150,000 out over the next 10 years by gifting $15,000 per year. It makes a lot of sense.
Yeah. That's a strategy that's deployed a lot of times. And then again, if we want to get creative, how we're gifting that and what we're doing for the children can actually create larger amounts of wealth for those children, especially if they're minor children. So there's a lot of creative strategies that are available that even people are utilizing. Like, again, you don't have to be subject to the $22.8 million. We have clients that they've recognized that they have assets that are over and above what they're going to need to live off of the rest of their life. And that it's much more rewarding to do that now than wait until they're dead when they don't get to experience it. Psychologically, studies have shown the best thing you can do for money from a psychological standpoint to receive happiness is give it away, right? And that could be charitable. It could be to your family. But that's been recognized. And so a lot of our clients, when they reach that, go, great. It has nothing to do with, I'm worried about $22.8 million or $3.5 million. It's going, you know what? I've got it. I'm not going to spend it. I'd rather give it to you today and see you and experience you enjoying that as a family rather than waiting until I'm dead and you guys, toasting me after the fact.
Yeah. Would it apply does it work the same way if I took out let's say I took out a whole life policy on a spouse, her the beneficiary, I'm paying into it. Does the 15,000 that I put into that whole life policy per year, does that count towards
you can give to your spouse? You can give to your spouse unlimited amount. There's no, right? There's no.
Okay, let's say it's not a spouse. Let's say it's my mom, right? Yeah. I take out a whole life insurance policy on her, or maybe a friend, right? Just somebody, not a spouse. My sister. I take out a whole life policy on her. And let's say I pay 15,000 in premiums into that whole life policy over the course of the year. Is that the $15,000 exemption?
Yeah, that's exactly right. You're gifting her $15,000. It's a piece of property. So you're gifting $15,000. You don't have to file a gift tax exclusion. It doesn't go against the $22 million or $11 million for you. It could be cash. It could be in securities. It could be, you're giving $15,000 of value. That's the current limit. So whatever you put it in, that is the current limit. But yes, you got the gist of it. That's exactly right. So whoever it is, now it's usually in family. It's usually gifting is done. Like I said, it's hey, you were going to receive this when I died anyway. Let's do it now. And there is some creative, fun solutions. If clients find themselves in that position, there's some really cool things that we can do with that for the families that again, we say the term multi-generational wealth for a lot of people, and understandably so. It's sort of like that's so far out there. But for some of these people, they've just been good savers. They've run good businesses. They've been good savers. They didn't overextend themselves. And they arrived at this point where they're comfortable saying, hey, we can live the life we want to live. And I don't care how long we live. There's no way we're going to spend all this money. And it doesn't mean they've got, deck of millions of dollars, but they've got the ability to do that and they want to do it. And then we can show them some cool ways where, people will be saying their name for 100 years later by doing some cool gifting strategies and how they deploy it and how it can help pay for things like college and weddings. And, it's like, and that money will be perpetuated for multiple generations. So there's some really fun stuff we could do there.
How soon would you begin a whole life policy on your children?
So some people do it. So this is an interesting conversation, and again, individually specific. So let's actually broaden that conversation, because many clients want to save money for their children for many reasons, right? So we talk about assets like a 529 plan. You have a custodian account. Custodian account means you're literally giving the money to your children, but you're going to be the custodian of that until they reach the age of majority. That's called an UTMA or an UGMA account. Different states have different rules, but primarily the children get ownership of that at 18 years old or 21, depending on the laws of the state. You've got trusts, which we talked about. I could put money in a trust for my child. Life insurance is another asset. So those are 4 different options of several. I could actually, if you have a business that your child can actually partake in, you could also pay them a salary, right? You could actually, if we have clients whose children are in their brochures and do modeling for their website, and so they're getting paid an amount of money every year through payroll that's tax deductible to the business, and their children get it, and you can put that into a Roth IRA as a custodian. So there's a lot of ways that you can transfer money to children, and it's really how much control of the asset is important to you, and when you want your children to have access to that money, right? So if you go down the line one by one, a 529 plan, very, very popular. We hear about it. It's in the ether. 529 plan, you put money away, you name your child as the beneficiary. So you own the account, your child is the beneficiary of that. That money goes in, it grows tax-free. It's an after-tax contribution. Some states have a state income tax deduction, but it's an after-tax contribution. The money grows tax-free and can be utilized primarily as meant for what's called post-secondary education. They have broadened it, so now you can use it for private school or high school if you want. But it was created to be for post-secondary school education, and that can be college, it can be vocational school, it can be continuing education, but it's education only, education-related expenses. If it's used for anything else, you've broken the agreement, and you have to pay an excise tax and penalty on it. So that's a cool way to do it, but that's single use, education only. Some people like doing that.
Timeline? What's the term on that? Like how? Like when can I begin to utilize the funds without penalty?
So they actually did broaden it. You can put it in on a Monday and take it out on a Tuesday for like private school education. There's no, because in New York, for instance, there is a state income tax deduction. However, you only get the deduction if you keep it in there for college. But like, if Jon Harris wanted to fund a 529 plan for for a master's program next year, you could put it in this year and use it next year, right? There's actually not a limit on that. It used to be only post-secondary education, only after high school, but they did open that up. So you can fund a 529 plan and use it to pay for private school for your children if they want to go to a private high school, if they get the opportunity. Yeah. But for that, we talk about that. So you have some control. You can change the beneficiary. That money can stay there for generations. Like if your child gets a scholarship, you could just name your grandchild down the road as a beneficiary. You could change it to another child, but it's education only, single use. Okay. UTMA or UGMA, you can use for anything you want as a custodian as long as it's for the benefit of the child. So I put money away. I've got a lot more flexibility. I can help buy their first car. I could send them some camps. I can use that for education if I want to. You don't get the tax benefits of a 529, right? There are specific tax rules about it. And when your child reaches the age of majority defined by the laws of that state, that money belongs to them. Okay, so if you use 21 as an example, if there's money in that account at age 21, your name comes off the custodial and they could come to me and go, hey, empty that account, I'm buying a Ferrari. And I have to say yes, they own the account, right? So you lose control. So some people go, I don't love that, but I can use it for anything I want. So a lot more control over what you can utilize it for. Doesn't have the tax benefits of a 529, but the ability to do it, your child gets control of that money at the age of majority. Then you look at trusts. People go, I don't want my kids getting money at 21. I was responsible at 21. I feel like it was, but if you gave me a large sum of money at 21, it was probably gone by 21 and a half. So you go look at a trust and you go, I'm going to put money in a trust for my child. The trustee designates the distribution. So we can still use it for whatever we want, but the trustee decides, and you can dictate, the trust can dictate, I want 50% of this, 25% distributed at age 30, the remaining 50% distributed at 35, the remaining amount distributed at 40. You can pick your ages. You can say how it's done. Those trusts are set up for control. Trusts come with expense. Cost money to set them up. Cost money to maintain them. Trusts have to pay tax returns or create tax returns. So again, you're generally only doing trusts at a certain income and asset level, and it's to protect the money from the children. And you have a trustee that controls that money that is still for the benefit of the children, but they get to decide what's being distributed. Then you've got whole life insurance, which we talked about. It doesn't have to be whole life insurance, any kind of life insurance that has equity or building. Again, the adult, the parent can actually own that asset. There's no age limit at which they have to transfer it. You get the similar tax treatment to a 529, meaning it's after tax dollars that go in. You get tax-free accumulation inside the contract, tax advantage withdrawals. You need to have an advisor. It tells you how you can access that money. You can borrow against it or take withdrawals to what's called your cost basis, tax-free, and then above that could be taxed. So if you're not doing it right, you have to be careful there. What people like about that, complete control. You can give it to your child at whatever age you want to. Complete access to the cash to utilize for whatever you want. No limitation on at all what we want to use for that cash, right? Guarantees. So it's not, if we're talking about whole life in this case, no market-based exposure. Some people like that. And that death benefit wrapper, you're securing health and you have death benefit wrapper that, again, this can be multi-generational. So you think about putting a little bit on a young child. By the time that child reaches their life expectancy at 80, 82, 84, who knows what it's going to be at that point in time. Now there's a large transfer of wealth that started when you were, you're 40 years old, you do that. And then 100 years later, there's still money floating around from that decision. So all of those decisions, again, it's individually specific, what's important to you, what's going on. Do you want to save money for your children? How much control do you want? How much risk on that on that money do we want? And a lot of times it ends up being a combination of a number of these things, mm-hmm. right? Many of our clients start saving money for their children starting at birth into multiple of these buckets, creating sort of that balanced profile that we always like.
Okay. I think most folks are pretty familiar with the differences between term and whole life. A term, obviously, you purchase that for a term, premium's a lot lower, lasts for 10 years. Problem with that is if I get a term policy at 20, it's very cheap, but at 30, it's going to be more expensive and I'm going to have to renew it. So I've got coverage. Premium's a little bit cheaper. And then whole life is permanent insurance. So you are purchasing that for permanently for the long term. Premium's going to be quite a bit higher, but you don't run the risk of having to renew it when you're 65 and the premium's going to be astronomically high. And then the other benefit of whole is that it accumulates a cash value, whereas term doesn't. Can you briefly talk about two things? Why should I put money, let's say college education, why should I put money in a whole life policy rather than just my checking account or savings account? And maybe to my understanding, it's simply just you're getting a better rate, but maybe there's some other benefits there. And then secondly is the different types of whole life that are used in scenarios like this, like whole life and universal life and variable universal life. Can you kind of touch on the differences of those real quick?
Yeah, so it's a very, very broad spectrum. What you just touched on is important. So like whole life is one type of permanent. It was we'll call it ordinary. It was the original form of life insurance. When you go back literally hundreds of years, it was communities coming together, putting money into a pool to protect each other for life, right? But individuals had access to equity based on what they put in because of life events. And then over time, the industry created different types of products to serve different needs for various clients. And so you've got term insurance, which was recognizing, hey, many people just need to protect a financial risk for a stated period of time. We can decrease the premiums drastically by identifying that actually many people don't die during this period of time. And the coverage terminates at a certain age. Universal life was an iteration after that recognized in a high interest rate environment of the 1980s, late 70s, early 80s, that we can create a product that's based on interest and sort of separate, unwind the premiums, the death benefit, and the interest, and identify those as three different things, and performance works. But then interest rates came down, and so then there was variable, which was based on investment accounts, and then there's index. So there's been a lot of innovation in the life insurance industry. All of them different. All of them have different risk profiles. All of them have different desired outcomes. And again, it's why important, whether you're doing estate planning or family financial planning, to understand differences in how they fit. From a efficiency or effective, from an efficiency standpoint, where you're doing planning, there are several things that I think are important. One, it's about the outcome. It's about the output, right? So when you have various different asset classes in your portfolio, different things that have different behavior, the idea is, what are the combination of these things going to do for you? And specifically for your family and what you're trying to do. So I'll give you an example. There are some people that we meet with and they go, hey, I have no interest in leaving my children anything. Like, it's great. You're talking about legacy and millions of dollars and estate planning. They go, I just want my last check to bounce the attorney on the way to the grave. Call it a day. I want to die with zero, right? And so you got to come up with a strategy to do that. But that strategy probably has to have some inherent guarantees, right? Because some people go, it's very important to me. I want to leave massive legacy. That strategy is probably going to have a different position of assets. Some people are risk averse. Some people love risk, right? So the incorporation of this as a product of life insurance as a tool inside a broader portfolio, again, it's going to be individually specific. However, what we have found, and actually was documented and studied by Ernst & Young, that came out and they wrote a white paper on it, is typically owning insurance, not for a term, but for life, typically having it for a long period of time, will create larger retirement incomes and larger legacy values by providing those inherent guarantees that the insurance companies, who are much better at handling risk than we are, provide. So in addition to owning all of these other asset classes, having investments, having retirement accounts, having businesses, it's creating the best outcome with the highest probability. And in many cases, for many of our clients and individuals, owning some type of life insurance is beneficial. What type it is really, again, depends on where you are in your life, how old you are, what your health looks like, what those premiums look like. So it's a dynamic conversation that requires tailoring to the individual.
Perfect. All right, man. I think we beat this subject to death. I know we've got to get on the tax side. We've also got to get on the legal side. So what I'm going to do is I'm going to plan to do a part 2 of this. Have this one.
Sure.
And by the way, for those of you that are watching and for those that did not have the opportunity to attend live this evening, this will obviously be on my YouTube channel. We are sending the recording out via email afterwards. CE will also go out for those that attended live afterwards. But we'll make this part 1 like basic estate planning. And then I think it would be a good idea to do a follow-up with Richard and, perhaps Lee Pennington or Chris Sands or someone who has has a footprint in this department to really dive a little bit deeper and cover it a little bit more comprehensively. But Ben, I'm grateful for your time this evening. You're a wealth of knowledge. I got a tremendous education. I've got 2 pages worth of notes on my iPad over here. So, and I've got some life changes coming up. I think here in the near future. So that's something you and I need to discuss because I think several of these things fall under this umbrella.
I can't wait to talk about it. I appreciate you having me on again. I look forward to expanding the discussion and bringing in some other professionals who can not only add more color, but probably correct me where I'm wrong. Like I said, it's a complex world and too much for one person to know everything about it. So let's definitely get that second one scheduled.
Yeah, and I think one other point to clarify is that this is certainly not a one size fits all type conversation. This is because there's a lot of different variables and it's a very complex landscape. I think that's why it becomes increasingly important to have very educated and experienced people in this field that can help navigate those variables to create a customized approach based on the specific needs and desires of each person. Because no 2 people's goals are the same and no 2 people's lives look the same. All that stuff different. And so it's because there's so many different tools that can be used. We want to make sure that we customize that approach so that it gets as close to the desired outcome as absolutely possible with all of the environmental circumstances factored in.
Absolutely. Could not agree more.
Yeah, and thank you for those that attended live this evening. Thanks so much for joining us. Appreciate your support. Please, if you would not mind taking a couple of minutes to complete the survey when we conclude the event. Definitely check it out on the YouTube channel. If you haven't done so already, please subscribe. That helps to grow the channel and helps allow me to get more of this content and stuff out there. With that said, I hope everyone, Ben, you and Stephanie, I hope you have a wonderful Christmas, New Year. If I don't talk to you before then, and that goes as well for everyone on the call this evening. I hope everyone has a very Merry Christmas. If there's anything that I can do or Ben can do to be of support to you, please don't hesitate to reach out to us. And we'll look forward to seeing you on another one of these very soon.
Cheers. Merry Christmas. Happy holidays, everybody. Thanks so much, Jon. Appreciate you.
All right. Yes, sir.
All right. Bye.